Now.
No matter what happens, I did get here, and I did tell the truth, and I have spoken up for what I've been carrying on my back reluctantly for 6 years.
Welcome back to Court TV Live. We're in the final day now of testimony in Johnny Depp and Amber Heard's multi-million-dollar defamation trial. Depp still has 7 hours remaining for his case today, but perhaps the most significant testimony came yesterday when he took the stand himself for a second time. On direct examination, Depp disputed the claims against him, and he addressed everything from the abuse he says he suffered at the hands of Amber Heard to her role in Aquaman. Let's listen.
Have never in my life committed sexual battery, physical abuse, all these outlandish, outrageous stories of me committing these things and living with it for 6 years and waiting to be able to bring the truth out.
And what happened while you and Miss Heard were together on the Orient Express?
There were times when it was very agreeable, very nice. And then there were times when something had become dissatisfactory for her, and she would start the rant, the blooming of a fight would be on deck there, and at one point, it didn't. I mean, I don't remember it lasting long at all. I just remember that I took a pretty good shot to the face, to the eye, to somewhere up here. So I had a bit of a shiner. But it all ended, and then everything got fine again, and we'd go to dinner, and it was all fine.
Did Miss Heard ever apologize to you for giving you the shiner?
I don't recall.
And approximately where was your hand when the vodka bottle hit it?
It was leaning. My arm was leaning on the marble bar, right there where the imaginary seat is, and leaning, kind of just leaning back and looking at Miss Heard. She just walked away with the second bottle. She walked this way when she threw the first bottle, which is actually visible.
Can you please circle where the first? Yeah. Could you please circle where the first bottle is?
Oh, sorry, excuse me. Yeah. All that is the exploded first bottle that went past my head, and the second bottle hit right up here where my hand was resting on the marble bar.
Do you recall Miss Heard testifying that you did not assist her in getting her role in Aquaman?
Yes, I do, yes.
And what is your response to that?
It's not exactly true.
Do you know when Miss Heard first auditioned for Aquaman?
I was scheduled with my band, the Hollywood Vampires. We had done 2 shows at the Roxy, which is a place in Los Angeles. We were invited to play at the Rock in Rio concert, which is a huge rock and roll festival. So we did the 2 shows to go to Rio. Miss Heard wanted to come with me, and Whitney, her sister, had come as well. While we were there in Rio, we were rehearsing and getting ready for the show. Miss Heard informed me that she would have to get back to Los Angeles for an audition. Basically, after our 2-hour show or whatever, we would have to get on the plane immediately to make it back to Los Angeles.
When were you performing at the Rock in Rio?
Oh, sorry. Yeah, that was I believe it was the 24th of September.
In what year?
That was 15.
All right, joining us once again, we have law professor at University of Georgia and former prosecutor Melissa Redmond in Atlanta, and forensic criminologist Dr. Laura Pettler joining us in Monroe, North Carolina. So that was Johnny Depp's sequel in court. He took the stand again yesterday. Ms. Redmond, how do you think he did in his rebuttal?
I don't think he did as well as he did the first time, honestly. I think there was a lot to be desired. Some things he did on cross-examination that were not particularly helpful to his case. Some denials he made where he could have just admitted sending some of the text messages and just moving on instead of letting the Amber Heard's attorneys harp on it for several minutes. And I think the part about whether or not he got Amber Heard's got her the part in Aquaman, whether or not he did anything to try to get her fired from Aquaman, could have been left to closing arguments with the evidence we've already seen. I would not have wanted to use my time in rebuttal to talk about those issues when those are not the major issues in the case. I think they had enough to argue that someone of his influence in Hollywood could have gotten his fiance or his girlfriend at the time an audition, or that he made a call when he felt like he was being defamed or lies were being told on him to executives to let them know this is the type of person, and I didn't know that at the time that I recommended her to you. I think you could have argued that. I don't think I would have spent time on rebuttal rehashing that of all the incidents we've heard of throughout the course of the trial. I don't think that would have been the point I would have spent time making, whether or not he got her the part.
Yeah. And by the way, we're going to get a little deeper into cross-examination and replay parts of that testimony in our next segment. But also, before we move ahead, I want to get your take on it, Ms. Pettler. You know, from kind of a forensic standpoint, how does that jive with what we've heard on the stand, and particularly what we heard from Johnny Depp yesterday?
You know, one of the things that we always do with any kind of victim or subject or witness that we are evaluating for authenticity and likability and all of these things that are very important in the trial process when jurors are watching them and listening to them is the body language and the tone they use, what we call idiolect, which is the way someone speaks very, very idiosyncratically versus other people, the word choice and the sentence structure. And I agree with Ms. Redmond. I think that he was a little bit different than he was the first time, but he wasn't less authentic to me. I do agree that he definitely could have just moved on from some of those particular items instead of opening the door to more questions about them or even more discussion about them. So, you know, from my take as a criminologist, it's different, obviously, than an attorney. Because I'm looking at a lot of the behavior, and I'm in this trial, not only am I looking for the damages, but I'm also looking for the predominant aggressor, the pattern of violence between them. And violence can be in any form, whether it's emotional, psychological, sexual, financial, physical. And, you know, it's important to recognize all of these things towards the absolute defense of truth versus defamation.
And, by most accounts, one of the most brilliant moments of the day yesterday for Depp's team on Rebuttal was calling Kate Moss. And she testified via video link from the United Kingdom, recounting basically her version of the staircase incident that had been described very differently by Amber Heard. So let's go ahead and listen to Kate Moss.
Did Mr. Depp push you in any way down the stairs?
No.
During the course of your relationship, did he ever push you down any stairs?
No, he never pushed me, kicked me, or threw me down any stairs.
So what specifically had you actually told Miss Heard about the incident with Miss Moss and the stairs?
Very simply that we were in Jamaica. I had left our bungalow about 3 minutes prior to her. I was standing outside and suddenly rain starts just coming down like it's, monsoon. And then I remember looking and seeing Kate coming out the door, and there were 3 little wooden stairs, and she slipped, her legs went up, and she landed directly on her coccyx and her lower back. And she was obviously physically in pain, and she was hurt, she was crying. So I ran over and grabbed her to make sure she was all right. That's it. That's all I ever. That's the whole story. But then the rumor of it, I'd never heard a rumor of that before Miss Heard grabbed hold of it.
Okay, so Ms. Redmond, you hear that. We hear this from Johnny Depp recounting the staircase incident. Kate Moss herself saying, no, he never pushed me downstairs, whatever, Amber Heard's insinuating. And Amber Heard is the one who brought up Kate Moss's name in her own testimony. How much does that damage Amber Heard's credibility?
A lot, because she is the one that's painting Johnny Depp as this abuser. And she intimated to the jury that he's been abusive before, that he threw a former girlfriend down a flight of stairs. That's something very dramatic. That's something very violent and very vivid, of that imagery of someone being thrown down the stairs. So to have witnesses come forward to say that never happened, I never told her that happened, and I don't know why she would make up this incident, leaves the impression to the jury that she will be able to make up other incidents, other allegations of violence that may not be true, because this was categorically denied by all of the parties involved. And there's no other eyewitnesses to say that it happened any other way than what Johnny Depp and Kate Moss testified to.
Yeah, and this is a mostly male jury, let's point out, so they might be sympathetic to the former supermodel, Kate Moss. We'll see about that. All right, coming up, we're going to take a look at how Depp did on cross-examination yesterday and some of the inconsistencies that were brought out in his testimony next on Court TV Live.
screen right now.
Welcome back to Court TV Live. We're just moments away from the final day of testimony in Johnny Depp and Amber Heard's dueling defamation cases out of Fairfax, Virginia. Depp will continue his rebuttal case this morning, and then it will be Heard's turn to put on hers. Jurors were able to get one last impression of Depp on the stand yesterday when he testified for a second time, telling jurors the allegations against him were completely false. But during cross-examination, Heard's attorney, Ben Rottenborn, was able to present Depp with several text messages and photos that seemed to contradict his earlier statements. Let's watch.
You've said before that if you want to be with a woman sexually, that she is rightfully yours, haven't you?
Could you repeat that?
And you've also said that with
Could you repeat that, please?
Yeah, that if you want to be with a woman sexually, that she is rightfully yours.
That's ludicrous.
You've also said that with respect to women that you want to be with, you've remarked, I need, I want, I take, haven't you?
Equally as ludicrous, no.
Can you pull up DX883, please?
You can pull it what you like. I've never said those words.
Mr. Depp, we can show the full unredacted. You've looked at a number of text messages in this case, and the words him as the identifier, that's you, correct? In every text message we've seen in this case.
Yeah, sure. It still doesn't mean it hasn't been screwed with. That's not anything that I've ever said or written.
Mr. Depp, in these pictures that were taken before you got on the train ride for your honeymoon, where you claim that Miss Heard hit you and gave you a black eye, you have the exact same shadow or sunburn or mark under your left eye. The exact same mark, don't you?
That's the, when you get a side light, you see the occipital bone. So that is the exact area.
Yep. And it's actually...
A side light will cause that.
Yeah, well, the picture's not being taken from the side, is it? It's being taken head on, isn't it?
No. The lens in front,
yeah.
The light on the side will cause that occipital bone, I believe it's called, to appear sunken.
Just like lights on the side of a train car, correct?
Objection calls for speculation.
You can take that down, Michelle.
That was, in fact, in the dark. And I had a chef, I had people on either side of me, so.
Mr. Depp, this is the same picture, or the same, the exact same scene displayed in PX 162 that you looked at this morning, correct?
That looks like my face has been, the eyes have been photoshopped.
Mr. Depp, you testified previously that the vodka bottle that you allege cut off your finger was a handle of vodka, correct?
Yes.
You've already testified to that.
The second bottle, there was a handle on that bottle,
right.
Yes.
This bottle, whatever it is, to the extent it's glass at all, that's in the corner of this room, that's not a handle of vodka.
Objection calls for speculation.
I think you'll find that I said 2 bottles.
Yep. And that's not a handle. Neither of those are handles of vodka.
Well, it's that big. It's broken. The handle's up the top on those vodka bottles, sir.
There is no picture of a handle of vodka broken on that floor, is there, Mr. Depp?
No, I don't see it.
And on June 4th, 2016, Mr. Depp, you texted your sister, I want her replaced on that WB film. Did I read that right?
You did.
Her is referring to Amber, right?
That's correct.
And WB is Warner Brothers, correct?
Again, correct, yes.
And then after you sent this text to your sister, following the temporary restraining order, you reached out to Guy Silverstein to have him fire Amber, correct?
Who?
Greg Silverstein, I'm sorry.
I don't recall reaching out to Greg Silverstein.
And in this text, Mr. Depp, you said, she's begging for total global humiliation. She's gonna get it. I'm gonna need your texts about San Francisco, brother. I'm even sorry to ask, but she sucked Mollusk's crooked and he gave her some lawyers. I have no mercy, no fear, and not an ounce of emotion, or what I once thought was love for this gold-digging, low-level, dime-a-dozen, mushy, pointless, dangling, overused, flappy fish market. I'm so happy she wants to go to fight this out. She will hit the wall hard, and I cannot wait to have this waste of a guzzler out of my life. I met a sublime little Russian here, which made me realize the time I blew on that 50-cent stripper. I wouldn't touch her with a glove. I can only hope that karma kicks in and takes the gift of breath from her. Sorry, man, but now I will stop at nothing. Let's see if Mollusk has a pair. Come see me face to face. I'll show him things he's never seen before, like the other side of his when I slice it off. Did I read that right?
You did.
All right, let's bring back in our guest, law professor at University of Georgia and former prosecutor Melissa Redmond in Atlanta, and forensic criminologist Dr. Laura Pettler in North Carolina joining us. Okay, Ms. Pettler, when you listen to that, how does that strike you? I mean, that whole interaction, that really aggressive cross-examination by Ben Rottenborn, and then Johnny Depp's kind of cool, calm responses.
I think that is how Johnny Depp is most of the time. I mean, we've seen him in several different situations now. We've seen him under duress and being confronted by Mr. Rottenborn, first on the initial cross-examination and now the second on rebuttal. And I think that Johnny Depp handled himself pretty well. I think that he was confronted with some really difficult things to say, that if he did say those things or text those things, it was said with definitely, he was very angry, and he really, I thought, handled himself well, because those things were very difficult to hear. I thought Amber Heard's reaction in the courtroom was also very interesting, and that she was appearing to be very saddened by listening to that. And it was one way or the other, whether it's true or not, it certainly was a disturbing thing to hear for anybody, about anybody else.
Yeah, Ms. Redmond, what do you think? Do you agree? And do you think that Rottenborn's style of cross-examination might actually boomerang?
I agree. I think it was impactful for the jury, especially because you have to imagine that the jury, while they're hearing this language and hearing these text messages, they're looking at both Johnny Depp and Amber Heard, looking for those reactions. Johnny Depp is very cool, say yes, that's what the text messages says. He's not necessarily admitting to all of them, but he does admit that the him in the text messages refers to himself, and that the words that were being read by Mr. Rottenberg were what was in those text messages. And then we have that emotion coming from Amber Heard, being very hurt by what she's hearing. I think Johnny Depp could have just admitted that I was angry at the time. He would have been able to explain on redirect why he was so angry if he felt like Amber Heard was intentionally trying to destroy his career by spreading what he characterizes as lies about him, and he wanted to revenge or was hurt or angry at the time. I think that's all perfectly understandable and a little bit more believable than these text messages are doctored and it looks exactly like all of the other text messages that you've seen from me or heard from me.
Yeah, well, thank you so much, both ladies, for your insight and analysis. Of course, we're going to keep watching Amber Heard versus Johnny Depp. Live testimony expected to resume about 17 minutes from now. But we also continue to follow the other major legal stories happening around the nation, including the latest developments in the manhunt for a Texas woman wanted for the killing of an elite cyclist. This is a love triangle murder case. Investigators suspect this woman, 34-year-old Caitlin Armstrong, is involved in the May 11th shooting death of cycling star Anna Mariah Wilson. A massive nationwide search is now underway for Armstrong. The U.S. Marshal Service released surveillance video of Armstrong, the agency saying that she boarded a flight from Austin to Houston's Hobby Airport just 3 days after the shooting, and she then boarded a connecting flight, investigators say, to New York's LaGuardia Airport. Court TV's Vinnie Politan spoke with Deputy U.S. Marshal Brandon Villa about the search.
Originally, we focused here in Austin, and now we can say now we're going to New York, and we will try to find out what her association is there. And we're hoping that the public will give us some type of insight of a tip, and maybe she got on some type of Uber or Lyft, and they'll remember transferring her somewhere on a ride. So that's really where our hopes are at right now, until we can find out that that destination point, or what type of association or family members that she may have in that area.
Armstrong is suspected of killing Wilson in Austin after finding out that Wilson had an affair with Armstrong's boyfriend. Wilson was in Texas training for an upcoming race near Waco when a friend she was staying with discovered her body. If you have any information, you can call that number on your screen, 800-336-0102. Also have an update on another trial that we've been following closely here on Court TV. An Oregon jury has now reached a verdict in the romance novelist murder trial of Nancy Brophy. She's accused of killing her own husband, Dan, after writing a blog post called How to Murder Your Husband. Here is the verdict.
We, the jury, duly impaneled and sworn in the above entitled cause, do find our verdicts upon the counts submitted to us as follows. Count 1, murder in the second degree, guilty.
Nancy Brophy will be sentenced on Monday, June 13th. For more on her case, you can go to courttv.com. And still ahead, it is the final week of the Johnny Depp versus Amber Heard defamation trial. The final days for hundreds of Depp fans to see the stars outside and inside court. Next, we're going to catch up with a few of Amber Heard's supporters as well as we count down to live testimony resuming just about 14 minutes from now. So keep it right here on Court TV Live.
Hard work pays off.
All right, so that's Johnny Depp arriving to the Fairfax, Virginia courthouse just moments ago, and we're just moments away now from the final day of testimony in Johnny Depp versus Amber Heard. They're dueling defamation cases, the anticipation building inside and outside the courtroom. Clearly, fans have been lining up every day outside that courthouse, and a majority of the fans are there, as you could probably gather, to support Johnny Depp. But Court TV's Chanley Painter did catch up with a few of Amber Heard's supporters. Let's listen.
And why are you here today?
To support Amber Heard.
What are you hoping, by being here, hoping to accomplish?
I don't know if I'm hoping to really accomplish anything. It's just, I wasn't even like a fan before, but I was looking online because I saw like just this horrific treatment of this woman for seemingly like no reason. And there was no one supporting her. Everyone was just joining in. They were turning her sexual assault testimony into a funny TikTok trend where they act it out. They go and they harass her outside of the courthouse every day, and they boo at her and they call her a liar. They say, "We don't believe you, Amber." And it just made me sick. It just made my stomach turn. I couldn't believe what I was watching. And no one was doing anything about it. So this is what I would want someone to do for me, I guess. Like, if I were all alone and the entire world hated me for telling a truth that they didn't want to hear and they were harassing me, I would hope that someone would care enough to come and support me. So, and I feel like I'm the only one here, and that just blows my mind, and it breaks my heart.
And actually, just moments ago, Amber Heard arrived at the courthouse. Let's watch.
Good morning. How are you?
2 more days.
Okay, so still with us, we have law professor from the University of Georgia, former prosecutor Melissa Redmond, joining us here in Atlanta. Forensic criminologist Dr. Laura Pettler in North Carolina. So looking at kind of the fanfare, particularly surrounding Johnny Depp, what kind of impact does that have on the proceedings here, Ms. Redmond?
We hope not much. We hope that the jury is not impacted by what's happening outside the courthouse. I believe in this courthouse. I'm not entirely sure that there's a separate interest from the jury. Of course, we don't know what they see driving in, how early the people line up outside the courthouse to show their support for Johnny Depp. But nevertheless, they will be instructed, and they have been instructed, to disregard what they're seeing outside the courtroom, to make their decision not based on sympathy towards either party, not based on animosity toward either party, but rather the evidence and the testimony that they're hearing in the courtroom. And all we could do is hope that they abide by that oath that they take to do so.
Yeah, and actually there is a separate entrance for the jury, but nevertheless, I mean, that's a huge spectacle that we're seeing outside the courthouse. And Chanley Painter just reported, you know, they line up starting at 1 a.m., these fans coming out to see Johnny Depp. What do you think, Ms. Pettler? I mean, is it just kind of human nature to be swayed by that?
I think that the majority of the country that follows Hollywood, follows these stars, they definitely have a vested interest in what is happening with their favorite actors. And so, unfortunately, I don't know how anybody couldn't notice what's going on out there. And to the woman that was talking earlier about that she came there to support Amber Heard, I do think that Amber Heard has been vilified. And in this particular trial, it must be very difficult for her to hear all of that every day versus what Johnny Depp is hearing every day. And I have, no idea how it might impact the jury. But as Ms. Redmond said, I hope it doesn't at all. And they take into consideration what the core of the trial is about. Did the defamation, or did what Amber Heard say defame Johnny Depp, and did what he said and his attorney say defame her? We haven't heard a pervasive pattern of violence in his past, but we have heard in testimony that she came to the relationship with a history of violence in her past.
All right. Well, thank you so much for your insight and analysis. Dr. Laura Petler joining us. And again, we're just less than 5 minutes away now from live testimony resuming in Fairfax, Virginia. So keep it right here on Court TV.
licensed everything.
You've said before that if you want to be with the woman sexually, that she is rightfully yours, haven't you?
That's ludicrous. I had vetted Ms. Heard.
Mr. Depp, you got your chance to speak this morning. Your Honor,
Warner Brothers had 2 franchises.
Mr. Depp, if you could just answer the questions.
And that's not a handle. Neither of those are handles of vodka.
It's that big. It's broken. The handle's up the top.
Mr. Neumeister, what's your opinion about the authenticity here?
There's no way for any forensic expert to validate any of these photos.
No matter what happens, I did get here, and I did tell the truth.
We're still on track to have closing arguments on Friday morning.
Welcome to Court TV Live. The courtroom battle between Johnny Depp versus Amber Heard gets underway at any moment in Fairfax, Virginia. Court TV cameras are there for it all. The judge on the bench. Let's listen.
Do we have any preliminary matters at this time? Very brief. Okay, sure. If you want to come forward.
So it is the final day of testimony now. Depp's team expected to wrap up their rebuttal case this morning with just one more witness, and it will then be up to Heard's legal team to present their rebuttal case. Of course, the big question this morning is, will Heard retake the witness stand, giving her the final word in this trial? Closing arguments are set for tomorrow. Both sides are up against a time limit set by the judge. Heard's team has just 1 hour left. Depp's team has 7 hours remaining. Want to bring in now law professor at the University of Georgia, former prosecutor Melissa Redmond, joining us in Atlanta. Waiting to see, again, if Heard is going to take the stand. What is your opinion? Do you think it's likely she will?
With an hour, 16 minutes, I don't think she will. I don't think that's enough time to clean up anything she would want to, or to make any explanations she would want the jury to hear. It would be rushed. So I don't anticipate she'll take the stand with that little amount of time left.
So interesting. Each parties have 61 hours, 15 minutes each, and this is how kind of we're coming to these calculations about Heard having an hour 16 left and Depp having 7 hours 8 minutes left. How common or unusual is it to have these sort of time limits in cases like these?
I think it's pretty uncommon. I've had judges say, I want this trial done in a week, I want it done in 2 weeks. But as far as the limit on the number of hours, other than how long you'll have for closing arguments, this is the first trial I've seen where the judge has set like 61 hours and 15 minutes. I'm curious as to how she came to that number. But it is the first case that I've seen where a judge has attached a number. It may be common practice in this jurisdiction.
Yeah, and it's interesting because Johnny Depp really takes his time on the stand. I'm wondering if that might be harmful or helpful to him. What do you think?
I think it's helpful because it gives the jury more time to observe him, to especially when as he's coming across as authentic and likable and charismatic. So the more the jury sees of that, the less likely they are to believe that he is the person that Amber Heard is painting him out to be.
Yeah, and so we're just watching the judge and the attorneys there, Benjamin Rottenborn for Amber Heard, Camille Vasquez for Johnny Depp there, and certainly she's emerged as a star in all this. Let's listen.
Okay, thank you.
And the jury is entering. So just moments away now from the continuation of testimony in Johnny Depp's rebuttal case. And again, the big question is, you see everyone rising now for the jury to enter. Big question for today is, Amber Heard going to take the stand? Something we're waiting to see. But Johnny Depp's team is expected to bring an expert today as a final witness in their rebuttal case. Again, they've got 7 hours left with their time. Ms. Redmond, what kind of expert would be most beneficial to them at this point?
Maybe someone who's, it's kind of hard to say because they pretty well covered everything. I would have ended with Johnny Depp. So.
Okay. Let's listen as they call their next witness.
Dr. Gilbert? No.
Sir, please face the clerk, raise your right hand.
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law?
I do.
Good morning, sir.
Good morning. Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon, and I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I trained in orthopedic surgery, and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years.
Okay. What percentage of your practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
Okay. And other than that 1/3 that involves surgery, what does the rest of your practice entail?
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively. A large portion of hand surgeons treat patients non-operatively.
In terms of the surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to tendinitis to injuries such as amputations, fractures, sharp lacerations, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994, so that would be 28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification? 2002. And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Okay. Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
Certainly less than 10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specializing in the hand.
All right, any objection?
No objection, Your Honor.
So moved.
So, Dr. Gilbert, what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs, pictures, as well as testimonies and depositions related to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his
right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was brought out was by Ms. Heard, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Okay. Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury, how would you describe the nature of the injury to Mr. Depp's finger?
Well, the nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture of the tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
Can we take a look at Plaintiff's Exhibit 60? And pull up to go to page 3. And Dr. Gilbert, are you familiar with this document?
Yes.
And what is it?
So these are two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection?
No objection.
All right, we'll identify it as 60, page 3, and publish to the jury.
And Dr. Gilbert, sorry to cut you off there.
Okay.
Can you just tell the jury what we're looking at here in this X-ray?
Two X-rays of Mr. Depp's right middle finger after the injury, and towards the tip of the finger, there's a fracture. Again, what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture closer to the joint.
In your view, what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as is seen in these X-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
So this orthopedic surgeon testifying in Johnny Depp's rebuttal case, we're going to hit pause here, but you're not going to miss a thing. We'll bring you back in where we're leaving off here on Court TV.
Download the free app now.
Welcome back to Court TV Live. It's the final day of testimony in Johnny Depp versus Amber Heard. An orthopedic surgeon has been on the stand now, is expected to be the final witness for Johnny Depp's rebuttal case, testifying about the injury that Johnny Depp describes that he suffered at the hands of Amber Heard. Let's get you back into court right where we left off.
What's your assessment of the description of the cause of the injury offered by Ms. Heard?
I think that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that a blunt force, solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Heard described?
So if you would have, if that were the cause of the injury, you would certainly, that would be a dorsally directed. So this is the dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed, and those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again I said is rare, so you would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any sign of anything like that?
None whatsoever.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded. So it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along the ulnar aspect of his finger.
Now, did you observe the testimony of Dr. Richard Moore?
Yes, I did.
And he testified about Mr. Depp's finger injury as well?
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes, okay. But not all of it.
Focusing on the parts that you, well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his interpretation of the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
Okay. What did you disagree with?
Well, I disagreed with several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
Okay. Anything else come to mind that you disagreed with?
Well, he also described that this was definite. Well, he thought that this was a pinching or what he described as an avulsion type injury, and that's referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges, it was not jagged. And generally when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss, and just to make sure we're on the same page, can you just tell the jury quickly what you're referring to there?
Right, so there were two components to this injury. One, the fracture of the bone, and two, he had loss of the soft tissues so that the bone was exposed. So that amputated part that was found at the bar.
Now, you were saying that Dr. Moore testified that this was an avulsion, and meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Well, again, in general, a pinch type injury results in one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged, and that's not what was depicted in the pictures.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
Correct.
What's your response to that?
I certainly believe that a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient force to result in this fracture and soft tissue loss.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all, the fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Do you have any opinion regarding the direction of the injury?
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence of fragments of broken glass in Mr. Depp's injury. Do you remember that?
Yes, I do.
And how does the absence of glass fragments factor into your analysis?
It really doesn't. I've seen hundreds, if not probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if just say a wine glass would explode or something of that nature, where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
Okay. I have no further questions, Your Honor.
All right, cross-examination.
Okay, so you have been listening now to direct examination of Johnny Depp's witness in his rebuttal case, an orthopedic surgeon testifying about his finger injury. We're going to take you to cross-examination on the other side of this break. You're not going to miss a thing. We'll bring you back in where we're leaving off here on Court TV.
Hey, hello? Mom.
Welcome back to Court TV Live. We continue bringing you live coverage of the final day of testimony in the dueling defamation cases of Johnny Depp and Amber Heard. Closing arguments are set for tomorrow. Right now, an orthopedic surgeon is on the stand. We just listened to his testimony on direct examination. Now let's take you in for cross-examination.
Thank you, Your Honor. Good morning, Dr. Gilbert.
Good morning.
Now, you're being paid $1,000 an hour for your work on this case, correct?
Correct.
And you agree, just to sum up, how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
Correct.
And you're aware, you said a few times Ms. Heard's account or Ms. Heard's explanation, right? You remember saying that?
Yes.
You're actually aware that Amber has said she doesn't know how he lost his finger. You're aware of that, right?
Yes.
So when you were just talking about Ms. Heard's account or Ms. Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger, correct?
No.
Yeah. You're aware that Ms. Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
No, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agree. Ms. Heard's testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger. You agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay. May I approach, Your Honor?
Yes, sir. Thank you.
Dr. Gilbert, you gave a deposition in this case on March 17th, correct?
Correct.
You were under oath in that deposition. You swore to tell the truth, correct?
Correct.
Okay, if you could turn to page 61, please. You see there are four pages per page of paper. It's on page 16 of the document.
Okay.
Okay, in line 9, you're asked a question, and then Amber's response to that question, that's the line 9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I am from reading this. I'm aware of the mechanism that she claimed would cause the finger injury. Question, but have you read anything so far that indicates she doesn't know how the finger injury happened? Answer, so far from what I'm reading here, yes. Did I read that right?
Yes.
And you've heard no testimony in this trial from Ms. Heard that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
Correct.
And you'd agree that the fingernail was uninjured. You said that, right?
Correct.
And the nail bed was uninjured.
Correct.
Correct. But the area under the fingernail, in the pulp of the finger, that's where the injury took place, right?
It was not isolated to the pulp, no.
But it didn't injure the fingernail, that's my question.
Correct,
Okay.
yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at him from 10 feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from.
Correct.
Right? But she threw it on a downward trajectory, correct? There's no allegation, you've never read anything that she somehow underhanded it so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you've already testified there was no glass in the wound, right?
Correct.
You haven't read any record of that in any medical records, correct?
Correct.
You also haven't read anything about there being cuts on the rest of his hand, right?
Correct.
And there was no glass found anywhere on the rest of his hand, correct?
Correct.
No bruising or injury on any other part of his hand other than the tip of his middle finger.
Correct.
And somehow, under Mr. Depp's theory, that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail, correct?
Correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did. don't you?
I said that it likely did, but I was not there, and I don't have videotape of the injury, so I can't determine that definitively.
Okay. Well, let's turn to page 25 of your deposition, please, on page 7.
I'm sorry,
Page 25 and 26. So it's page 7 of the document.
Okay.
Sorry if I was unclear on that.
No problem. I'm there.
Okay. Line 18, question, and to be clear, by, quote, sitting in that position, you mean hand down, palmar side down. Answer, that's what he claimed. I mean, according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmar side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred, and as well, you can't determine if his hand had moved at some point during the course of the injury, which I believe it probably did, which I didn't get into in my note here, but question, and why do you believe that? Have you read anything in any of the materials to suggest that? Answer, no. Just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's incorrect.
Okay, that's what you testified to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
That is incorrect. That's not what I testified. That's
In
not
fact,
what
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation is that it didn't happen how Mr. Depp says it did, correct?
I cannot make that assumption, nor can you.
No further questions.
All right, redirect.
All right, so you've just been listening to cross-examination by Attorney Benjamin Rottenborn for Amber Heard of that witness for Johnny Depp. We're going to take you to redirect examination on this final day of testimony in Johnny Depp versus Amber Heard. You're not going to miss a thing right here on Court TV Live.
tried today.
Welcome back to Court TV Live. It's the final day of testimony in the dueling defamation cases of Johnny Depp and Amber Heard. Also, Depp's final witness on the stand right now, an orthopedic surgeon, just finished up with a cross-examination. Now want to take you in for redirect examination.
Dr. Gilbert, just very briefly, the absence of other cuts on Mr. Depp's hand, how do you factor that into your analysis?
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanism of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example, if you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury impacted the hand at that point in time.
Ms. Heard's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Correct.
And how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
Okay. And your discussion of Ms. Heard's explanation of the alternative cause of the injury, was that based on anything other than Ms. Heard's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you.
Should I do this too?
You can just leave it there. That's fine. Thank you, sir.
Thank you.
All right. Your next witness.
Plaintiff rest, Your Honor.
All right. Plaintiff rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure.
All right, so there you have it. Johnny Depp's legal team has rested his rebuttal case. Want to bring back in law professor from the University of Georgia, also former prosecutor Melissa Redmond, joining us from Atlanta. Ms. Redmond, what kind of note was that to leave off on in Johnny Depp's rebuttal?
It was a pretty strong note. Surprisingly, I didn't think they could add much more to their case, but to have an orthopedic surgeon come in to say this injury could have very well happened exactly the way Johnny Depp described. And when you couple that with how descriptive he was in giving the explanation of how it happened, how he played it out for the jury, I think is pretty compelling. He did say that he can't discount some other injury or some other way of the injury happening, but to end saying that yet again we have another witness lending credibility to Johnny Depp's versions of events was a good way to end their case, to rest their case.
Yeah, and so Amber Heard, her legal team is set to resume to begin their rebuttal case. And, you know, they've just got about an hour and 16 minutes left because there was a time limit of 61 hours and 15 minutes for each side here. What do you think they need to do in their time remaining?
I think whatever they can do to shore up her version of events of at least one of these incidents, because again, they just have to show that he abused her on one occasion and that she did not lie about that. I think they should pick their strongest incident, whatever they can prove or whatever additional evidence they can offer to shore up that, that particular incident.
All right, so let's go back into court to see about Amber Heard's rebuttal.
He has to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case for penalty of law? Yes.
Good morning.
Morning.
Can you please state your name?
Julian Ackert.
And can you please describe your educational background following high school?
I have a Bachelor of Science in Computer Science from the University of Virginia.
What is your profession?
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data preservation and collection strategies, doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata analysis of the evidence that I extract.
You mentioned collecting data from forensic collections. What material are you forensically imaging?
This would be any type of material that stores digital evidence, an iPhone, an iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GIAC GCFE, that's the GIAC Certified Forensic Examiner certification.
And what were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any professional organizations?
I do. I'm a member of a conference called the Sedona Conference. It's a conference that is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
And has a court ever declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Acker as an expert in the field of computer forensics.
No objection, Your Honor.
All right, so moved. Could you just spell your last name for me, Mr. Acker?
Ackert, A-C-K-E-R-T.
Thank you so much, sir.
Mr. Acker, what is forensic imaging?
Forensic imaging is the process of capturing the data on a digital device in a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So, for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets, PDF files, any applications that you ran, the history of what you've opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to do that?
Log files list information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
What is the purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the data from the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracting photographs or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
I do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's an evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to.
So a computer forensic analyst testifying in Amber Heard's rebuttal case. We're going to hit pause, but you're not going to miss a thing. We're going to bring you back in where we're leaving off here on Court TV.
Go to pumpkin.care.
Welcome to Court TV Live. It is the final day of testimony in the blockbuster defamation trial between Johnny Depp and Amber Heard. Depp's legal team rested their rebuttal case a short time ago, and now Heard's legal team is giving its rebuttal. On the stand right now is a computer forensic analyst, so let's pick it up right where we left off.
Medium or large or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's two types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And Mr. Neumeister was concerned with embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh operating system for laptops. This is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, it could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version on those photos.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So the photo that was originally taken traverses or gets synchronized to other devices by design of Apple, and that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software EXIF metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up Defendant's Exhibit 1671? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying what the contents, just generally, what is it?
This is a chart I created as part of my report.
Your Honor, permission to publish Defendant 671 is a demonstrative.
Any objection?
No objection, Your Honor.
All right. It'll be published as a demonstrative.
Mr. Acker, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second. A little further up. Great.
Thank you. This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Heard's devices that did not indicate the software metadata field showing photos. Rather, they indicated that they were the original software metadata field of iOS.
And do you see the second column titled Neumeister report date captured?
Yes, I do.
What does the information in that column mean?
This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured, or the date captured is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
Can you just scroll to the next page, please, Michelle? Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry, the right-hand column of this chart?
Yes, I do.
And where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for each of the items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect, for example, a phone or a laptop, and the matching file name found on that evidence ID that indicated the original version of this same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up, what does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and follows by another number is an iTunes backup.
So what, if any, what items in this right-hand column, based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up to iCloud, and those are coming from an iOS backup in iCloud. Everything else is coming from an actual physical device.
Can you just take this down for a second, Michelle, and pull up 1675, please? Defendant 1675. And do you recognize this chart, Mr. Ackert?
Yes, I do.
Without yet getting into the contents, can you please describe generally what it is?
This is a chart that I prepared as a summary of my findings.
Permission to publish Defendant 1675 is a demonstrative, Your Honor.
Any objection?
No objection.
All right, 1675 will be published as demonstrative.
Can you please describe in more detail what the three columns you can see in this chart represent?
Sure, this starts to give some detail about the particular evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected. A11, 12, and 13, slightly down, are three different laptops that were collected for Amber.
And do you see the IDS evidence number column?
Yes, I do.
Do you see the source type column?
Yes, I do.
In the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671? Thank you. So, Mr. Actor, can you please describe the relationship between these two demonstrative exhibits?
Certainly. If you look at 1671, the one on the left, you can see in the fourth column the different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for example, the picture Neumeister referenced on page 24, or I guess that's the second one, there are equivalent versions or original versions of those that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop, same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified a photograph on page 30 taken on December 16th, 2015, and he was concerned about the EXIF metadata of that, showing the software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad, and it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across your devices when you take them.
Mr. Acker, you can take this down, Michelle. Do you recall Mr. Neumeister's testimony regarding what he claims of EXIF metadata modification?
Yes, I do. This is a completely hypothetical scenario. Mr. Neumeister never specified any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today made to a reasonable degree of forensic certainty?
Yes, they are.
No further questions, Your Honor.
All right. Cross-examination, sir.
All right, so we have just been hearing that testimony from a computer forensic analyst in Amber Heard's rebuttal case. We're going to take you to cross-examination on the other side of this break. You're not going to miss a thing, so keep it right here on Court TV Live.
Prepare for free at thezebra.com now.
Welcome back to Court TV Live. It's the final day of testimony in the blockbuster defamation trial between Johnny Depp and Amber Heard. Heard's legal team is giving its rebuttal, and on the stand now is a computer forensic analyst. Let's take you back in right where we left off with cross-examination.
Thank you, Your Honor. Good morning, sir.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before?
Give or take, yes.
For more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
No, I can testify to the ones that Mr. Neumeister identified with specificity.
Right, but there were thousands of photographs provided that Mr. Neumeister didn't testify about, right?
I have no opinions on any photographs that the opposing expert has no opinions on.
All right. My question to you, though, is as you sit here today, can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
All right. You'll agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph, right?
Yes.
Yeah, you just talked about it, right?
Yes.
All right. And you'll agree with me that the XF data of some of the photos produced by Ms. Heard reflect the use of a photo editing application?
No.
No?
I'll agree that they show the use of the Photos application, which is a sorting and editing application.
Okay, so what you were quibbling with is that it will both sort and edit.
That is correct.
Okay. Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered into evidence in this court. Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712 and Defendant's 713 next to one another? Your Honor, these have already been admitted, and I ask that we publish it to the jury.
Okay, if they're admitted, we can publish.
Can you see this, sir?
Yes, I can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that down. Mr. Gibson, can you pull up Plaintiff's Exhibit 1308? This has not been admitted, Your Honor, and I propose to use it as a demonstrative.
Any objection?
Not as a demonstrative, Your Honor.
All right. Be identified and published to the jury as a demonstrative.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no. No objection, Your Honor.
No objection. All right, it's in evidence then.
All right. 1308 is in evidence. Mr. Gibson, can you blow up the time, date, and file name? Sir, you just agreed with me that those two photos are different photos, correct?
I agreed that they were visually different, yes.
Right. So they are two visually different photos that were created at the exact same hour, the exact same minute, the exact same second as each other, correct?
That's what the daytime metadata shows, yes.
And the metadata shows something else too. They have the exact same file name, don't they, sir?
Yes, but that's not embedded metadata.
Right. How would you have this jury decide which one is real?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view, look visually different, correct?
I don't agree that they have the same identifying information. I don't see a software metadata field here.
The identifying information includes the hour, minute, and second they were taken, this picture were taken.
I see that.
No further questions.
All right, and just for the record, since we already have 712 and 713 in evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just to keep the record clean, okay? All right.
Thank you, Your Honor.
Redirect.
Mr. Acker, you just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all of the photo metadata you have reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you were responding to?
Can you repeat that question, please?
Yeah. Based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to, do you have any reason to question the forensic authenticity of those photos?
I do not.
Following your cross-examination, Mr. Acker, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of forensic certainty?
Yes.
No further questions, Your
All
Honor.
right, thank you. Sir, you can have a seat in the courtroom or you're free to go. All right. Did you want to approach just for a moment?
All right, so now a sidebar getting underway. We just heard from that computer forensic analyst testifying about the metadata concerning the photos in Amber Heard's rebuttal case. Amber Heard's team is set to call another witness, and we're going to take you into court for that. You're not going to miss a thing, so keep it right here on Court TV, your front row seat to justice. Court TV Live, we continue our coverage of the dueling defamation cases of Amber Heard and Johnny Depp. Johnny Depp has now rested his rebuttal case, during which time he actually called a psychologist to the stand who challenged the PTSD diagnosis of Amber Heard by her own expert psychologist, Dr. Don Hughes. Now, we've just heard the first witness for Amber Heard's rebuttal case, who is a computer forensic analyst. And now it's time to hear from Dr. Don Hughes, recalled to take the stand once again. So let's bring you back into court.
All right, Dr. Hughes. Thank you, Doctor. Just a reminder that you're still under oath, okay, ma'am?
Yes, Your Honor.
Thank you.
And could you please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours.
Okay. And why are you here today?
To offer a rebuttal testimony to Shannon Curry's testimony of yesterday.
Okay. Now, Dr. Curry said you used improper methods. Would you agree with that?
No, I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis-driven procedure where you're looking at a variety of different details and tests and external data to arrive at an opinion, and you're looking at the consistency across that data. There are 3 sort of sets of tests that we use as forensic psychologists, and I think that's where it seems that Dr. Curry seems confused. We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court. For competency, if someone has competency to stand trial, we have very clear measures that can track that legal criteria. The next level are forensically relevant instruments. And those instruments are not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure. So the malingering measure that I utilized was the MFAST, and that was the only malingering measure in this case. The third category are clinical assessment instruments, and those are instruments that are validated and well-researched and used in the clinical realm as we understand people's symptomatology and diagnostic and functional capacities. Those are things like the MMPI, the PAI, the CAPS, the TSI, because they are clinically relevant and they still give us very valuable information to individuals who are involved in a court case. And the reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. They're not in a courtroom. So they're well-validated and well-researched methods. What we also do is use a very different types of tests within that category. We use some checklists, some face valid checklists. We use some tests that are those broadband personality inventories. We use structured clinical interviews. And then we look for the consistency across those data points. And when we use different types of tests, it gives us information about the individual, how they go about these tests in these different modalities.
Now, Dr. Curry seemed to suggest that Amber Heard tested the most extreme category in all of these different tests. Is that accurate?
Objection, compound.
Overruled.
That is not accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time, this happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms that I determined was accurate and reliable.
Now, Dr. Curry also suggested that Amber Heard was tested very, very high, 98th percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things, so let's go through those tests. The first was the PAI, and that's that other broadband psychological
Objection,
measure.
non-responsive.
I think it's very responsive.
Sustained.
Okay. Could you tell the jury about the PAI test that Dr. Curry addressed?
Yes, thank you. So that's the broadband measure that has validity scales built into it that gives us indications about how the individual goes about the test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What Dr. Curry was talking about was this tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there are two other measures that we look at that to say, you know, is this enough for an elevation for me to consider that as a serious response distortion, of which Dr. Curry was saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity, and on affective instability. Those were the four scales that were elevated on this test. The borderline scale was not elevated on this test. And this test...
Objection, Your Honor. May we approach?
Yes.
Okay, so we are now hearing from Dr. Don Hughes, psychologist for Amber Heard, testifying for the second time now in Amber Heard's rebuttal case. Want to bring in our guest analyst at this hour, law professor at the University of Georgia and former prosecutor Melissa Redmond, joining us in Atlanta, and here in the studio with us, criminal defense attorney, former prosecutor Marie Pereira. And Marie, very interesting that you also are a registered nurse and work with domestic violence victims as well. Marie, since we haven't had a chance to hear from you yet, I want to ask your take about some of this testimony, particularly surrounding the photos of purported injuries to Amber Heard.
I think they want to question the photos because they're saying that she doctored up the photos. But even if she did doctor up the photos do not show the level of violence that Ms. Heard claims Johnny Depp exercised against her. So on a good day, the photos still make her look like she embellishes. It makes her look like she's lying, and the jurors are going to see that. So I don't understand why they're wasting their last hour and whatever few minutes they have, when I say they, the Heard team, on bringing in another forensic computer specialist to say she didn't doctor up the photos. Because even the undoctored photos land her in trouble. And I think that they should just avoid putting people on the stand that are so repetitious and not helping their cause. You don't have to RSVP to every rebuttal party and call back every witness. You could simply say, I have no further questions or no more witnesses. They're hurting themselves at this point.
And, you know, Melissa, I think we started to discuss this. I mean, Heard's team had an hour and 16 minutes to do their rebuttal. Is this how you would use this time?
Absolutely not. This is really getting into the weeds about something that's kind of collateral to the issue at hand, whether or not Johnny Depp abused her on any occasion such that she did not defame him, that she was being truthful in her op-ed. That's the issue. Getting into whether or not she doctored a couple of photos, whether or not they appear, the jury's going to look at the photos. So they're going to say, well, these photos look different. Something is different about these pictures. It is what it is. Don't spend all of this time on something that at the end of the day doesn't help your case at all.
All right. Well, thank you so much, ladies, for your analysis. And of course, we're going to bring you back into court for Amber Heard's rebuttal case, this last day of testimony in Amber Heard versus Johnny Depp. So keep it right here on Court TV Live. Welcome back to Court TV Live, the final day of testimony in Johnny Depp versus Amber Heard. It's Amber Heard's rebuttal case now underway. We want to bring you back to the testimony of Dr. Hughes, psychologist testifying in Amber Heard's rebuttal case. Let's bring you back in where we left off.
Dr. Curry, let's move to the TSI-2. Dr. Curry testified about your findings on that. Did you agree with her testimony yesterday?
No, again.
Please describe why. Explain why.
What Dr. Curry went back to, which is this 98th percentile, which I told you in the manual. All you have to do is read the manual. It says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she is therefore not qualified to interpret it. That score, the one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of exaggerated symptoms where I can't further look at that test. Secondly, there are 3 scales out of maybe there's about 20, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out those memories and not think about them. And then relational avoidance, a way of having difficulty in interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for your interpretations. Do you agree with that?
No.
Please explain to the jury.
So the MFAS, as I told you last time, is a measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry did not independently administer a measure of malingering, and there are other ones that she could have done to augment her evaluation. And she kept saying something that MFAS is not for malingered PTSD. That's wrong on a couple levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms that they have, and they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering measure to get a sense of how this person is responding to this evaluation. Now, what you do is you take those 3 tests that I talked to you about, the PAI, the TSI, and the MFAS, all with valid validity scales. You have greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report. That bolsters the methodology that I used. That in a study that had the PAI, the MFAS, and the TSI in the title of detecting feigned from bona fide PTSD.
Thank you. Now, Dr. Curry also talked about the danger assessment scale and suggested that you had inappropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Which I told you last time, the danger assessment scale has statistically validated risk factors for serious or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or if we look backward and we look retrospectively about what factors may have been present in a case that indicated severity. That instrument is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been killed, a homicide has occurred in a domestic situation. They look at these risk factors to see what was there and what could be done.
All right. Dr. Curry also criticized your administering of the CAPS-5. Do you agree with her criticisms?
I do not.
Will you please explain to the jury?
So the CAPS-5, as you all have heard multiple times, is a structured clinical interview in determining PTSD according to DSM-5 criteria. On this measure, Amber Heard scored in a moderate range. She did not over-exaggerate on this test. She could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s. None above that. So she's scoring in the moderate range, which still has functional impairments. I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile or an exaggerated response style of someone who's answering an instrument.
All right. And the last of these Dr. Curry referred to was the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is as she said, it is a face valid instrument. It means it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of validity scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over-exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment. And that's what I did. I took what she wrote, what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria for PTSD. That is something we do clinically, and I do in my office all the time. And yes, she did meet PTSD from that in January 2021.
Thank you. Now, Dr. Curry said you misinterpreted her test results. Do you agree with that?
Yeah, I agree that I agree that I interpreted them, that she misinterpreted them.
Okay. And please explain that.
Yeah, so I said that before. My stance on the MMPI and how she interpreted it is, I believe, wrong, and I think most...
Objection, Your Honor.
All right.
That's the issue we just addressed.
All right.
I don't...
If you want to approach.
Okay, so you've just been hearing from Dr. Dawn Hughes disputing Dr. Curry's diagnosis of Amber Heard and essentially defending her own diagnosis that Amber Heard did, in fact, suffer PTSD. Of course, just to kind of recap for everyone, if you're just joining us, this is the rebuttal case of Amber Heard in what is the final day of testimony of Johnny Depp versus Amber Heard, day 23 in the trial. Sidebar is done, so let's take you back into court.
That a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form.
Objection.
Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who are struggling with PTSD or trauma-based disorders, and I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma's going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS, Ms. Heard had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Okay. Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is understanding.
Narrative.
All right. Next question. That's the question.
Okay. Now, Dr. Curry suggested that you made a determination just based on personal opinion and just on checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests and reviewing a slew of documents in this case, most importantly, therapy records and interviews, collateral interviews with therapists, using all that data. That is what a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
And just to remind, to make sure we're reminded here, you were qualified in this court, in this case, as an expert in forensic psychology, specifically in domestic violence and in no, I just lost it. And in violence, correct? Intimate, and in trauma, correct?
Objection, Your Honor, misstates the record.
If you want to ask the question again.
Yeah, I probably should do that. You were qualified. I got to find my note. You were qualified as an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case?
That's correct.
Okay. Now, do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do you still hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right, cross-examination.
Yes, Your Honor, but can we approach quickly?
Sure.
Okay, so still with us, we have a law professor at the University of Georgia and former prosecutor Melissa Redmond joining us in Atlanta and here in our studios, criminal defense attorney and former prosecutor Marie Pereira. Ms. Pereira, you have pointed out that Amber Heard might have an issue overcoming the fact that she lacks photographic evidence here. What you've seen out of her rebuttal case, is she overcoming that?
No, she's not overcoming it. She brought in a forensics expert who is an expert. He's a purchased person just like anyone else. I think what she needs to do is to bring in some independent, corroborated evidence, not doctored photos, maybe people who could back up her story. And she hasn't done that with the few hours that she has, less than an hour now. She's not proving her case.
Ms. Redmond, what do you think, how do you think she's doing? Is she proving her case? Is she doing what she needs to do?
I don't think she's doing what she needs to do in the little bit of time she has left. I think if you're going to bring up your expert to say that Johnny Depp's expert was wrong, you say that very quickly. She's talking fast and using a lot of clinical speak that I think is going to go over the head of the jury. I think it would have been a much better use of her time to use her rebuttal to say, this is how I know Amber Heard experienced evidence of trauma based on these evaluations, and this is, and keep it short and sweet. I think it went on way too long and way too much detail that's going to go over the head of the jury.
Yeah, Ms. Redmond, I know you have a background as being not just an attorney, but a registered nurse and a domestic violence advocate as well. From what you've seen, is this credible? Is this narrative from Amber Heard credible?
The narrative is credible, but as it pertains to Amber Heard, no. The photographs do not match the type of injury that she's explaining happened, and that's extremely problematic. Amber Heard would not be able to chew if he hit her that many times in her face. She would have swelling, lacerations, maxillofacial injuries, and she hasn't proven that even with the allegedly doctored photographs. So she needs to bring in independent proof about these allegations.
All right, well, thank you so much for your insight and analysis. Attorneys Melissa Redmond and Marie Pereira joining us. Keep it right here on Court TV Live.
Oh, privacy simplified.
Good Thursday afternoon to you. This is Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host. Thank you for being with us as we are on the final day of testimony in the dueling defamation trial involving ex-spouses and Hollywood actors Johnny Depp and Amber Heard. So the judge has set Friday for the day for closing arguments, and that is the day that the jury will then get the case.
Plaintiff rests, Your Honor.
All right, plaintiff rests the rebuttal case.
All right, so that was what happened this morning. The Depp team rested its rebuttal case. Now, Amber Heard is able to do what's called sur-rebuttal in the law, the response to the rebuttal. So, we are going to take you back into the courtroom in just a moment, but also we're expecting to have jury instructions gone over as well at some point today. And if our cameras are able to show that to you, we certainly will. So right now, Amber Heard has called to the stand Dr. Hughes. She was somebody that testified in the case in chief for Amber Heard earlier, and now she's rebutting that testimony from Dr. Curry. So this all has to do with the mental health aspect of this case. We know Amber Heard put her mental health at issue, meaning that she made it part of the pleadings, saying that she suffers from PTSD because of what she says Johnny Depp did to her in the way of domestic violence. Let's go back into the courtroom now where we left off.
Good morning, Dr. Hughes.
Good morning, Mr. Dennison.
The last time you were here, I believed that you testified that you had diagnosed Ms. Heard with PTSD before you gave the gold standard CAPS-5 test.
That's correct.
Right. And that diagnosis is actually reflected in the first of the disclosures you put forward in this case.
I believe the first disclosure was February 2021, and at that point I had done 11 psychological tests. That's correct.
Right. And your disclosure reads, Ms. Heard's responses on the PCL-5 support a DSM-5 diagnosis of post-traumatic stress disorder with an etiology of intimate partner violence she experienced by her former partner. You remember writing that?
That's correct.
Okay. You just testified that you need to read the manual, right?
Yes.
Okay. Can we put up 1311 as a demonstrative?
Any objection to 1311?
I don't know what it is, Your Honor.
All right, if you want to
May
lay.
we approach?
You want to approach?
Tom.
All right, while the attorneys are approaching Her Honor to have a sidebar, let me bring in my guest. So excited to have Marie Pereira in the studio. She's a criminal defense attorney, former prosecutor, also has experience in the domestic violence prevention movement, and you're even a registered nurse as well. You do it all, Marie. With these experts, you know, Dr. Shannon Hughes, Dr. Don Hughes, Dr. Shannon Curry, kind of battling it out, how important is this issue of Amber Heard's mental health as part of the pleadings in that she did in fact or did not suffer from PTSD?
I think it's important, but not important enough for them to be wasting precious rebuttal time on this. We've heard it before. They're talking over the heads of the jurors, and at this point, it's like, womp, 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 womp. Even to me.
The Charlie Brown teacher.
Even to me.
Right, Marie. You know, I was thinking that with the doctor we saw the Depp team call, how much more are we going to hear about the hand? You know, sometimes there is that risk. I know you know this because you're a seasoned trial attorney. You can over-try a case, can't you? And that's a risk you run with the jury, huh?
Absolutely. I thought the doctor fell flat. I expected the doctor was going to come in, the doctor for Depp was going to come in and testify about high-velocity injury. Because if you remember, in Depp's testimony, he said when he went to the doctor in Australia, fresh off the chop, the doctor said, look, I know you're saying you closed it in a big accordion door, but I've seen injuries like this, and this is a high-velocity injury. But since that's what you're saying, I'm not going to question you. He needed to bring that doctor in or someone comparable to that doctor to explain his lie. Because he lied about it, and now he wants us to believe that's how it happened. He needed to do better. His expert fell flat, and to be honest, Amber's expert orthopedist did a better job in alleging that it couldn't have happened that way. They didn't rebut properly.
Bingo.
They didn't.
Bingo. And therein lies the problem, Marie, the lie that he told. You know, it's hard to then go back to the jury and say, well, I lied to my doctor. That's a time when you know the rules of evidence provide for communications you make to your doctor for purposes of diagnosing you or treating you. That is reliable hearsay always. So definitely an exception to the hearsay rule because who would lie to their doctor, right? You want the proper treatment and the proper care. So with that being said, that sidebar is over. Let's go back in now to hear some more from Dr. Hughes.
Let's use 1312.
1312, okay. And that, any objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
Dr. Hughes, do you recognize what the National Center for PTSD is?
What it is?
Yeah.
Yes, I do.
And they publish the PTSD checklist for DSM-5.
That's correct.
That what we've been calling the PCL-5.
Correct.
All right. And do you, are you familiar with the document that's on your screen?
Yes.
All right. What is it?
It's the instruction manual to how to administer the PCL-5.
Okay. I'd like to move for the admission of 1312.
Any objection to 1312 coming into evidence? All right, 1312 in evidence.
All right. Can we go to the second page? Can we blow up the second paragraph on the right? That's the PCL-5 should not be used as a standalone diagnostic tool. When considering a diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g., the CAPS-5, to determine a diagnosis, correct? That's what the manual says.
Right, and this manual
Okay.
also says that this is a screening instrument, so when you do the clinical interviewing, you absolutely can determine diagnosis
So
after
the answer is
somebody
yes. The manual says you
still
the
need to use
PCL-5
clinical interviewing skills, which I used.
Well, let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5 to determine a diagnosis, correct?
It does say that, yes.
Yeah, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical interviewing and 11 other psychological tests that supported diagnosis of PTSD and symptomatology consistent with PTSD.
Okay. You said that we should read the manual. Would you also agree with me that we need to read the directions on these tests?
Sure.
Okay. Tom, can you pull up 1309 as a demonstrative?
Yes, sir. Thank you. Any objection of 1309 as a demonstrative?
May we approach?
Okay.
Okay. They're asking to approach Her Honor again. Lots of sidebars in this trial so that what's being discussed is not heard by the jury or us at home watching. Thank you for being with us this afternoon. I have a great guest in the studio with me, attorney Marie Pereira. Okay, Marie, this cross, is it doing anything for you as you're watching this?
It's not doing anything. I think it's a misuse of allotted hours, and they will regret that.
Yeah, the time is ticking. He's back at the podium. Let's listen.
Doctor, do you recognize the demonstrative that's in front of you.
Yes, but I didn't put the red lines on that.
No, I did.
Yes, I know.
Okay. So this, what do you recognize this as?
I recognize that we previously discussed this, and I told you that I oriented Ms. Heard to a different time frame because she was already out of the relationship.
Okay, maybe we should back it up a little. This is the CTS-2 that you administered as part of this battery of tests that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale 2.
All right. And you'll agree with me that this test specifically asks, in front of every single question, how often did this happen in the past year?
Correct, and I oriented
And
the
you
individual
know-
to not limit herself to the
correct.
last year to get an accurate assessment of the violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
All right. I'll move to strike the last part of the answer. Strike the last part of the answer. Thank you. Next question.
Yeah. And you know that at the time that you gave this test to Ms. Heard, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame in answering the questions.
Doctor, yes or no?
So, of course.
Okay, you knew she was gone for more than a year.
Of course.
All right. Let's look at another one of these. You talked about the I'm sorry. You talked about the danger assessment test.
That's correct.
All right.
All right, we're going to squeeze in a break. Don't go anywhere. This is Court TV Live, your front row seat to justice.
10% off your purchase.
Staying with us here on Court TV Live, I'm Julie Grant. Back into the courtroom we go to see more of the cross-examination of the Heard team's expert on forensic psychology, Dr. Don Hughes.
Dr. Hughes, this is a blank form, but this is the dangerous assessment test that you also gave to Ms. Heard, correct?
I didn't give it to her. I filled it out based on the data that was provided to me.
Oh, so you asked her the questions and then you filled it in?
It was somewhat collaborative.
Okay. Can we blow up the second full paragraph? It says, using the calendar, please mark the approximate dates during the past year when you were abused by your partner or ex-partner. You didn't use any calendar, did you?
I did not use a calendar because she was already out of the relationship. As I said, these are static risk factors, so they don't change. So I orient her to the time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that you were supposed to look over the past year. And that's not the language?
No, that's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this relationship.
I didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test not only on the previous year.
Nope, asking you about the instructions.
But I'm telling you how the test is administered in clinical practice and in forensic practice.
And opposing counsel can come up and ask questions about it. I'm asking you about the instructions. And the instructions say, look over the past year. And,
yeah, on this, yes, it says that.
And you had actual knowledge when you gave the test that Mr. Depp was gone way more than a year before this test.
That is correct.
Right. All right, let's look at more instructions. Can we look at 1247, which is already in evidence? Dr. Hughes, you recognize this one too, right?
Yes.
All right, this is what everybody calls the CAPS 5.
Correct.
All right, can we go to the first page? Let's blow up the instructions. Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Can we go to the next page? One more. Oh, wait, that's good. This is a page on scoring, and we talked about this last time.
Yes.
You score these tests by frequency and intensity.
Correct.
And you'll remember that in every single instance that you were asked to fill in the blank about frequency, you failed to do so, correct?
That's not correct.
Oh, you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I asked you whether you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's page down. Let's keep going. All right, we'll stay at this page for a second. This is the very first box you're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison. I had 88 pages of notes of what happened. It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review them. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
Right. But you chose to put absolutely nothing in the box, the standardized box, that said what happened.
You don't have to put it in the box if you have it somewhere else. It's not a,
Because this is not a standardized test?
Well, if it's not a research instrument that is used for research, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay, let's go another page or so. All right. Let's go another one. All right, let's look at item 4B4. And I asked you whether you filled in the blank about frequency. And there's a blank in many of these items that asks number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test?
Yes, correct.
No further questions.
All right, redirect.
Very briefly. You used the term static risk factor. What did you mean by that?
Static risk factors are risk factors that don't change. It's maybe if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you have, the greater likelihood that somebody's going to have psychological consequences and symptomatology as a result.
And therefore, you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the time frame in the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You have to understand, the traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner
Objection, Your Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages. I'm not asking her to give each of the specific events. She can describe the summary of it.
Can we come up?
Okay. What is the difference between clinical scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
Compound.
Sustained.
Your Honor, when it's compound, it's because it might be confusing to the jury.
Sustained. Next question.
Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test and research?
Objection, Your Honor. Compound.
Overruled. Good.
Sure. So the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma and what the person has experienced. And why those boxes may be relevant in research is because back in the day when I was a research assistant, I had to input that into the computer, and then they would maybe look at some of that data for the research study. So that becomes very important in research.
All right. Thank you. I have no further questions.
All right. Thank you, Dr. Hughes. You can have a
Thank
seat in the
you.
courtroom or you're free to go, okay?
Thank you very much.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess. Our morning recess. Let's take our 15-minute recess. Do not discuss the case with anybody and don't do any outside research, okay?
All right, so again, why that's important, because in the pleadings filed in this case, Amber Heard said she suffers from PTSD. That's why the Depp team expert was able to evaluate her, and that's why Johnny Depp didn't have to consent to any kind of evaluation, because he did not say that he's suffering from any kind of mental distress or mental health difficulty as a result of the domestic abuse that he says happened with him. So that's where the difference lies. When we come back, guess who we're going to hear from? Amber Heard. We're a little behind on the video, so I can tell you she has taken the stand in her rebuttal case. We'll be right back after this.
at lapiplasty.com.
Thank you for being with us here at Court TV Live. We are in the final stretch of Depp versus Heard. We're in Amber Heard's case where she gets to refute what Johnny Depp's team put on in rebuttal. And guess what? She is taking the stand. We have rewinded the video back so you can see it all. Let's go in together and watch.
Yes.
Your Honor, defendant calls Amber Heard.
All right, Ms. Heard, if you come to the stand, please. Yes, ma'am. Water. All right. Thank you, ma'am. And just a reminder, you're still under oath, okay?
Of course, Your Honor.
Thank you.
Thank you.
All right, your question?
Amber, just to orient you and the jury, at this time, we're in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine my questions to that, okay?
All right.
How have you suffered publicly as a result of the Depp-Waldman statements?
Objection, speculation.
Overruled.
I am harassed, humiliated, threatened every single day. Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave, and they tell me that. Johnny threatened, promised me that if I ever left, give him every single day that I lived.
Objection, Your Honor, non-responsive.
All right, I'll sustain the objection as to that. If you want to ask the question.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment, in the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake, I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir.
Unspoken rules.
Overruled. Go ahead.
About how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing, smiling, and making snide jokes. I'm not. This is horrible. This is painful. And this is humiliating for any human being to go through. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. Those statements, the attacks on me, the campaign, that Johnny has elicited millions of people to do on his behalf when he himself
Objection, Your Honor,
couldn't do
lack
it.
of foundation.
Torture me.
Speculation.
I'll sustain the objection. Next question.
Amber, how have the Depp-Waldman statements impacted your ability to do charitable work?
You know, the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have interests is
Objection,
because I'm not.
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Good.
It's because I found a solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, I was able to turn the things that I've lived through, my pain, my life experiences, into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it, but I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure.
Objection, non-responsive.
And I can't do my charity work.
Sustain the objection.
Amber, other than the threats that you've described, what other threats have you endured since the Depp-Waldman statements were made?
I receive hundreds of death threats regularly, if not daily. Thousands since this trial has started. People mocking my testimony about being assaulted, making fun of my...
Objection, relevance, non-responsive.
As to damages. You can continue.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this. I just want Johnny to leave me alone. I just want him to leave me alone. I've said that for years now, and I thought he would after 2020.
Objection, non-responsive.
All right, I'll sustain the objection. Next question.
What do you hope to reclaim after this is over?
Protecting the secret that I did for as long as I did has taken enough of my voice. Johnny has taken enough of my voice. I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American to talk about what happened to me, to own my story and my truth. I have that right. I hope to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Wow, that right there might have been the most powerful, poignant testimony we've heard from Amber Heard throughout this trial. We're going to step aside for a break, hitting that pause button as you saw. We'll see the cross-examination on the other side. Welcome back to Court TV Live. I'm Julie Grant. Amber Heard has returned to the witness stand when her team has a chance to do their rebuttal to the Depp rebuttal. So legally, the term Sir Rebuttal you may hear thrown out there. So this is her response. And if you're just now joining us, when she was asked how she has suffered publicly, she said she is harassed, humiliated, and threatened every single day, telling the jury about how it happens when she goes to and from the courthouse for this trial, saying this has been the most humiliating thing she's ever had to gone through, waking up screaming, shaking, and suffering because of what she says was domestic violence at the hands of her former spouse, Johnny Depp. Before we hear the cross-examination, I'm going to bring in my guest on the program. She has experience as a former prosecutor. She practices criminal defense work in New York City. She also has expertise in the area of domestic violence and is a registered nurse. Marie Pereira on the show. Marie, what did you think of her testimony on direct there, please?
I think what they're doing is what you've always said. At the end, it's primacy and recency. They want to put her out there in her best light. They want to humanize her, and she did a good job at it. However, this is a court of law. I am a domestic violence victim advocate. I don't have a side here. But even domestic violence victims need to prove allegations. And I don't think it's victim shaming to require that Amber Heard prove that she is a victim of domestic violence. She raised the issue in the op-ed. So therefore, it's not wrong to require her to prove it. There are two sides to every story. And for me, even with this humanizing statement that she's giving on the stand, very touching, talking about how it impacts her daughter. There are hateful people out there saying, put her baby in a microwave. That's horrible. No one needs to go through that.
Right.
However, this is a court of law, and if she's making these allegations, she has to prove them.
Right, and if the jury believes only one instance, only one of domestic violence, then Johnny Depp's claim would fail, because then it would make what she wrote in the op-ed true. Marie Pereira, always great to get your insight. I want to ask you about the cross after we see some of it. We're going to go back in now at the very beginning of the cross. It is Johnny Depp's attorney, Camille Vasquez, who's going to be questioning her.
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar.
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
Yes,
Johnny's
other than a light
employees
fixture, that was
testified
the
to
only
my
thing that was
closet being
broken, right, Ms.
rearranged
Heard?
and things
Ms.
like
Heard,
that.
the only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to strike everything after he summed it up that it was a light fixture as non-responsive.
She answered the question, Your Honor.
Overruled.
In the security guard testimony, Your Honor?
I'll allow it. Go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That isn't correct.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-party TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing a
Objection,
TRO,
Your Honor, this is not
we had
responsive.
no reason to
Move to
believe the
strike.
press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can, and Ms. Vasquez is misrepresenting to her what she testified to.
Well, I'll strike the last part as non-responsive.
Thank you,
Just if you could just answer the questions asked. Okay, thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up. In case.
You actually had alerted TMZ that you would be filing a TRO against Mr. Depp that very day,
No, I did
didn't
not.
you?
No, I did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I never did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes, and you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
All right. And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify that about this video as well yesterday, didn't you?
Yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX. Yes?
I don't know if that's I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was posted 15 minutes after TMZ received it. Yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible because it didn't come from me. I was flying.
Tremaine
So
testify.
I know that's incorrect, is what I mean to say.
Another liar on the stand?
I just know that that's incorrect.
Right. And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
The cabinet video you filmed of your then husband, yes?
The copyright ownership of that is news to me. I learned that yesterday.
It's the cabinet.
All right, we're gonna hit the pause button right here. I want to bring in my guest and see what she thinks of this cross-examination. Marie Pereira, go.
I feel like it's a little too aggressive. It's getting too girly. It's like they hate each other, and that shouldn't be. I think Camille needs to calm down, let the woman speak, because the more she speaks, the more she digs a hole for herself. She's saying, I'm not a saint, I'm a person. I didn't know TMZ was coming. So how did TMZ know that she was gonna be there? I'm a victim advocate. I helped to draft orders of protection for it to be presented to a judge.
That's awesome.
When these clients come in, it's private. Nobody knows they're coming. So she had to know they were coming. For her to deny that makes her look disingenuous, and that's the most recent thing they're gonna remember.
Mercy and recency, my friend. Marie Pereira, great to have you on with us. Thank you so much for sharing all of your insight today. We're gonna be right back with more Court TV Live after this.
Sick of annoying spam calls? RoboKiller eliminates 99% of unwanted calls. Download RoboKiller today.
This is Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. We are watching the final stretch of Amber Heard and Johnny Depp and their dueling defamation trial playing out in Virginia. Amber Heard's team gets to do rebuttal. She is on the stand, really pushing back on the cross-examination. You're seeing a little bit of a difference in the way Amber Heard is answering Camille Vasquez. And Camille Vasquez is being extremely aggressive with her. Let's go back in the moment where we left off.
Of your then husband, yes?
That is correct. I did capture that video, and yes, that was my husband.
The same cabinet video that was released the night before you were deposed in your divorce, yes?
That's correct.
Okay. You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that that you have seen is complete.
Right. But the one TMZ got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified that at the beginning portion of the video where you set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ received.
I'm talking about Mr. Tremaine's testimony, Ms. Heard. Let's just focus on Mr. Tremaine.
You're asking me to repeat his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes, I heard his testimony. We all did.
And he testified that the end of the video where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You edited
That video
out
did
the
not
portions.
come to me. Come from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMZ.
You're very wrong about that.
So
if I wanted to leak information, I could have done it in a more effective way, a lot sooner and a lot more.
Because you
I was
knew exactly
living
how to
with
do
a
that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
I thought you testified earlier in this trial that you didn't know how to leak things.
I don't.
Right. You edited that video before you gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
I'd like to show you a picture that's already admitted into evidence. It's Defendant's Exhibit 799. This is you at the courthouse on May 27th, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes.
Jody Gottlieb is your publicist?
And dear friend.
Yeah. Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316. This is a picture of you and your friend Rocky Pennington, right?
That is correct.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
All right, 1316 in evidence. You can publish to the jury.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken, and also I'm outside. I was obviously wearing makeup. I have no idea when this was taken, so I have no idea if I can speak to what bruise you can see or not.
Let's refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness? This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that.
And the article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Okay. Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you've treated all of these.
I'll sustain the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your Honor.
All right, 1317 in evidence, you can publish.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Let's zoom out of that picture for a moment, please. Thanks, Tom. That's Josh Drew in this picture, right?
Yes, that's correct.
And Ms. Pennington?
That is correct.
In there too?
That
Ms.
is correct.
Pennington submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes.
Ms. Hurd, I'd like to show you Defendant's Exhibit 512, which is already in evidence. You've seen this photograph before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident, yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context. Can we please, thanks, if I could have day 16 trial testimony? Your Honor, may we approach?
All right.
Could you please turn first to page 4585?
Sorry, 1 second.
Specifically starting on line 16, where it says, let's talk about December 15th, 2015.
You said 458, I'm on 4485, sorry. You said 4585.
4585.
Pardon.
Line 16. Line 16, where it says, let's talk about December 15th, 2015. Do you see that?
Yes.
Okay. And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12. 4603. Starting at line 12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that Defendant's Exhibit 512, which is on the screen,
Yes.
is a picture of the downstairs of the main apartment?
That's correct.
And the main apartment is Penthouse 5 in the Eastern Columbia building, right?
No, well, depends on what. The main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet. Mezzanine office was in between.
All right, so it's your testimony that Defendant's Exhibit 512 reflects damage to the penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence?
Again,
in relation to that incident.
Sorry, go ahead.
In relation to that incident on December 15th, 2015, this exhibit, Defendant's Exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial picture of a
Ms. Heard,
floor,
you didn't just
so
look
I
at a
can't.
picture. You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually leave up Defendant's 512 and please pull up Defendant's Exhibit 725, which is already in evidence.
Thank you.
In redacted form, Your Honor.
All right, thank you. You can publish.
Just side by side. You've seen this photograph as well, right?
I have.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't cover it up, Your Honor.
Could we unredact
Your Honor
them
did.
so we could get context?
That's how it's in evidence.
That's how it's
All
in
right.
evidence.
Next question.
Well, the metadata next to it is so that
Ms. Heard,
to avoid this
Ms.
sort of
Heard,
confusion.
there is no question pending, and I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
No, I didn't ask you about anything. Let's look at your direct testimony from the third day. Now, may I approach?
Yes, ma'am. Thank you.
Thank you.
Let's turn to page 4750 in day 17 transcript.
Sorry, can you repeat that?
4750. Specifically line 16. Do you see where Ms. Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
Okay. And do you see that your testimony is reflected about May 21, 2015?
Yes.
That follows? Okay.
Yes.
Now let's turn to page 4804. At line 14. 4804. Starting at line 14?
Yes.
Through 4805, line 4.
Going to what line?
Line 4 at 4805. Do you see that you're testifying that Defendant's Exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in Penthouse 5?
That's correct.
Okay. And Defendant's Exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
Okay. So which is it? Which one was taken on December 15th, 2015, or May 21st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of spilled wine on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Okay. Thank you, Tom. Ms. Heard, at the beginning of your cross-examination
Your
last
Honor, may
week...
we approach?
Yes.
All right, we are seeing a noticeably different Amber Heard, really giving some good pushback to Camille Vasquez. I'll tell you who's not pushing back is Amber Heard's attorney. So it's Benjamin Rottenborn who is tasked with lodging the objections for this portion of it. I have kept count since this cross started, and I have noted 20 objections that could have been made by the Heard team to improper questions asked by Camille Vasquez. And if you don't make the objection at the time, guess what? It is waived. You've got to protect your client when you are an attorney advocate. We're going to hit the pause button while they're at the sidebar. We'll be right back with more of Amber Heard's testimony after this.
Smile Direct Club.
Thanks Thanks for staying with us here at Court TV Live. I'm Julie Grant. We are watching Amber Heard be cross-examined. She is in her rebuttal case. She is getting the final word here. As we saw, Johnny Depp already had the chance to do his rebuttal. He went first because he is the plaintiff, filed the first action. She's also plaintiff too. Technically, that's what makes this trial quite confusing, because they're both making claims against the other and they're both defending claims against the other. And so there was a sidebar that was called for a few moments ago. It was kind of a long one. We fast forwarded the tape. Let's go back in now for more cross.
All right, ladies and gentlemen in the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right, your next question.
Ms. Heard, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you never assaulted, actually, strike that, sorry, Your Honor. When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Miss Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So you think Miss Moss needs to come out of the
woodwork
woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
and I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me? I didn't hear your question.
You didn't hear my question?
Ms. Vasquez, if you do mind,
Curry-
please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom?
I have
For a
seen people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect
Johnny
Keenan
doesn't-
Wyatt.
Johnny has never
Ms.
actually
Heard.
said that.
Ms. Heard.
And
I think the
Ben
jury
King,
can.
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp. after what you've put him through and so many others with your lies?
I
did you?
relate to Isaac because he and I are
There's
the
no
only
further
ones who have
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right. Redirect.
Thank you, Your Honor. Ms. Heard, if Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake an injury caused by Mr. Depp?
No.
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection.
Because there's so
Lack of
many-
foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to try to challenge this in this way. It's crazy. It's easy to not know the context of a picture of spilled wine because there are so many more important details, pictures, and also so much I didn't photograph, so much I didn't have the presence of mind.
Objection, non-responsive.
All right, I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically?
Yes.
Verbally?
Yes.
Emotionally?
Yes.
Psychologically?
Yes.
How did the threats that Mr. Depp made against you individually years ago resemble what you've endured as a result of the Depp-Waldman statements?
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out. And if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up, that revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block
Objection, Your Honor. Lack of foundation, speculation, hearsay,
It's all in
non-responsive.
I'll sustain as to non-responsive.
Ms. Heard, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Well, those are
Objection, Your Honor. Lack of foundation.
She's
overruled.
Thank you. Thank you, Your Honor.
Those are just an echo of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again. That's just an echo of the violence and the abuse that I suffered within our relationship. The campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks and for the whole world since our camera's here.
No further questions. Thank you so much, Amber.
All right, Ms. Heard, you can have a seat next to your attorneys. If I could have the attorneys approach. Just
A good point for counsel to end the questioning there with Amber Heard. Let me bring in my guest while they're at sidebar, criminal defense attorney Josh Schiffer. He practices in Atlanta, Georgia, has been watching this case closely since the outset. Josh, as we were watching this together, you and I were doing like the play-by-play, the color commentary. I want you to share with the viewers some of the things you were saying to me. You made some excellent points.
Oh, you're too kind, but this has been as gripping as it gets. And what we just watched, that's the last thing this jury's going to hear from either of the two litigants. Now, what we've seen for this entire trial, we've seen the Johnny Depp show pretty much since day one. Look at public opinion. Look at how the questions and the court has responded. It's been all about Johnny putting his case forward, and Amber's case hasn't been strong. We've all commented and wondered why, what's going on, and I think just like we've talked about earlier, at the end of this case, the argument's going to be what Amber just said, and she just elocuted it in the best way I've heard from her or anybody else, that it's impossible to fight Johnny Depp. Johnny Depp's always gonna win, and going into this trial, they knew that the Johnny Depp machine was just gonna crush her, end her career. And if the jury goes back into the room with that as the final feeling, not a thought, not a belief, a feeling, it bodes much better for Ms. Heard than people are giving credit to.
Right. You know, this case has had so much excitement and so many different layers to it. One thing that you and I talk about often with cases that we broadcast on Court TV is how attorneys really need to have a theme for their case. Those who really know how to try a case know you've got to have something thematically. And you just hit the nail on the head. When Josh and I were talking to each other as we were watching that, you identified something that is the perfect close for the Heard team. What you were just saying about going up against the Johnny Depp machine and how she's been powerless.
Yeah, and it really hits the victimhood, hits the fact that the power dynamic between them was never going to be equal in a million years. He was always going to be an A, she was always not going to be. Maybe she could aspire, but he was always going to have that power dynamic. And that dynamic existed, according to pretty much everyone, throughout their entire relationship. No one got up and testified, oh no, Amber's doing this, Johnny's doing that, and there's the control dynamic that was equal. No, it's been very clear. And so Amber's team has preserved the opportunity to reframe the case at close, just like you mentioned. This entire case is evidence of the perpetual and chronic domestic abuse that Amber Heard lived with throughout this entire relationship. And the trial itself and these jurors are now tools and part of continuing lopsided, bad dynamic, intimate partner violence. And if they can carry that theme home, make that theme in the end.
That's what the Heard team has to do. Josh Schiffer, thank you for that. The sidebar is broken up. Let's go back in now.
All right. Your next witness?
Your Honor, the counterclaimant Amber Heard rests.
All right. Thank you, ma'am. All right, ladies and gentlemen, you have heard all the evidence you're going to hear in this matter. What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a good restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m., and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go, tomorrow I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday or Monday, because Monday is a holiday. I would like to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the room at the same time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go, okay? So have a good evening, and we'll see you tomorrow morning, okay? Do not discuss the case with anybody. Don't do any outside research.
And do you know what that means? With that resting, all of the evidence in this case is finally in. Everything that is evidence, that E word that is so important that this jury is going to consider, because something to keep in mind as you watch the closing arguments tomorrow or when you hearken back to the opening statements, what the attorneys say is not evidence. Opening statements are not evidence. The closing arguments tomorrow are not evidence. They're simply a framework for the jury. It's a way that attorneys get to advocate for their clients and advocate for their respective positions to the jury or to the judge, however the case may be. So All of what the jury can consider as part of their fact-finding mission is now before them. They have heard it all. No more material is to come in Depp versus Heard. Only the closing arguments tomorrow, and then the jury gets this case. Let that sink in. Let me bring in my guest as we continue watching everybody moving about in the courtroom, that packed gallery. There must have been people talking, making noises, speaking up when we saw that sidebar called for. And then remember when we went back in for the cross, we heard Her Honor saying to the gallery, you're gonna be removed, you're gonna be out of here and you're not coming back in so many words because of that. And we know, Josh Schiffer, my guest here in the studio, that courtroom is packed day in and day out with die-hard Depp fans who I think it's safe to assume were saying something.
Yeah, this courtroom is turned up to 11. If you thought there was a lot of emotion jammed into a small, stuffy spot, this morning, I couldn't even imagine it. So the judge was being really vigilant, trying to make sure that the jury didn't get influenced by this throng of Johnny Depp supporters. And I have no doubt that someone was letting out some noises, probably in support or gasp of disbelief or astonishment. And Judge did the right thing, shut it down, because what we just witnessed, like you're saying, that's it. The jury's gonna hear 2 more arguments, get charged by a judge, and decide. This is all the evidence they're gonna have. They get to weigh what they're gonna accept and how they're gonna weigh it. That includes all those questions that got asked and objected to, because they can't put those questions back in the box. They got out there.
Thank you for saying that, my friend. That's the thing. You have to be quick. When you're a trial attorney, you have to be fast with objections, because you have to be ready to make it as soon as the question's out there before the witness answers. And like you said, it's waived. So, and what I mean by that word waived, let's say there's a question asked that is totally improper, totally objectionable, and I have seen countless. You and me, Josh, and all of our viewers at home don't have enough fingers and toes to count in this trial. I've seen so many of them. But guess what? Nobody can attack it on appeal if it creates an appealable issue, because nobody made the objection at the time.
It's going to be really interesting to see how that weighs in the jury's actual decision, because jurors don't know how objections really work. They get some instructions, but shoot, it took me 2 or 3 years to understand the difference between sustained and overruled, because I had to do the math in my head.
No, it's confusing.
It's hard.
Absolutely. And for anybody watching the trial, who's not a trained lawyer or a law student, it can be like, oh, wait, which one is it? What are we going for here? Yeah.
Giving the viewers kind of a peek behind the scenes, watching Julie watch this, literally every word out of your mouth under your breath is objection, compound, objection.
Oh yeah, I was.
Because we're sitting here being lawyers from 1,000 miles away, and it is that fast. But the jury's just watching as listeners. We don't know exactly what they valued the most. They're going to go back with their individual positions, with the evidence that they remember best. Talk about recency. That final testimony from Amber was powerful stuff. They're going to use their memories to make this decision after being charged. Right. And that's a whole nother discussion.
Right. She did very well on the stand today. And I'll share more of my list after the break, but I counted 32 objections that her counsel could have made. Just quickly, argumentative, misstating the testimony, counsel testifying. And in that case, when counsel testifies and just says something that's not a question, you stand up, you say objection, counsel's testifying, motion to strike counsel's statement, and Your Honor, I ask for an instruction to the jury to disregard it. That is the proper way you do it. Promise you, you can take it to the bank. All right, we're gonna go to a break. We'll be right back with more Court TV Live after this.
Go. Privacy simplified.
This is Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host. We just watched all of the evidence go into the case in this trial that's taken weeks to play out in Fairfax County, Virginia, between ex-spouses and Hollywood actors Johnny Depp and Amber Heard. So the way things worked out with the plaintiff and the defense and counterclaim and rebuttal and surrebuttal, Amber Heard wound up giving the last word to the jury. She was very powerful, very emotional, very poignant in her testimony. As somebody who's watched this trial closely, does not have a horse in the race. I'm not on Team Heard. I'm not on Team Depp. I'm on Team Court TV. We're facts and law. We call balls and strikes. That was the best I've seen her testify, really pushing back hard on Camille Vasquez. So much so, she pushed back. Camille Vasquez ended by just walking away, just like backing off from it. So Benjamin Rottenborn had an opportunity to ask a couple of good questions in the end about how this has affected Amber Heard. She said every day going to and from the courthouse is, in so many words, I'm paraphrasing here, a nightmare for her, being humiliated and harassed, and security has to work with her to come and go every day. And we want to show you her departing from the courthouse just a few moments ago. We've got some video of that. Let's take a look.
Right? The rope hanging yesterday.
And so if you watched her arrival this morning, you can tell that is a lot quieter. I'm guessing she's not near the crowd of people. I've heard some really ugly, obscene things chanted at her. And I'm getting word that we also have Johnny Depp's departure as well. Let's take a look at that.
Howdy. I have a feeling we will see each other again. Take care.
You want your phone, Z?
Boy, Johnny Depp knows how to work a room, doesn't he? Or the outside of the courthouse, I should say, shaking the hands of all of those sheriff's deputies, smiling for the cameras, waving to the fans. Without a doubt, he is a very beloved actor. All over the world, he has fans. We know his fans have traveled from far and wide to do this, what you're seeing right here. The waving, the cheering, bringing him gifts. They run after his SUV many days to hand him gifts when he has the window down. Certainly, when it comes to the court of public opinion, I think most people watching this trial carefully would have to agree that Johnny Depp is winning in the court of public opinion. But we know this case is being played out in a court of law. His fans are not the deciders in the end. The jury will be the finders of fact in this case. And it's very possible he may lose this case. It's very possible neither of them may win this case. It's very possible Amber Heard may lose. Anything can happen with a jury. Let me bring in someone who knows all about that, criminal defense attorney Josh Schiffer. Josh, you can never know, can you? All the years you've done this, anything's possible.
You can never predict this. If you've got a lawyer that promises you that they know what's going to happen, you need a different lawyer. Every good lawyer's lost cases they should have won, and the opposite way the same. What you just said, though, is super important for people to really bring home. The court of public opinion's one thing. Jury, totally different. the judge is going to specifically read the longest, most complicated set of instructions you've ever imagined. It's going to be dozens and dozens of pages thick. It's really complicated. And I believe that Amber's lawyers are going to come out and, just like you just said, this isn't about public opinion. They're going to embrace the fact that Amber is not a perfect victim. A lot of people are talking about the idea of an imperfect victim and whether imperfect victims still deserve or can even get justice. And by reframing what Amber's gone through, I think that's the pathway, the theme that gives the jury permission to accept all the glory about a super celebrity who everybody loves and hold against them the way that Amber's team needs them to do. And at the same time, Johnny has the strongest presentation out there. You just can't look away from someone with that much charisma, and it carries him a long way.
Oh, he's got it. I have said it many times. When it comes to the optics, Johnny Depp knocks it out of the park. He does. I mean, just now, that is exactly the way you do it. I mean, trust me, he's got it down pat.
It was the opposite of a perp walk.
We're gonna have to hit a quick break. So I'm being told, no, it is. I know it is the opposite. You're right, Josh. We should explain that. So I want to let everyone know we're going to be able to show, you were just talking about the jury instructions. The judge is going to have the attorneys back in a couple of minutes to go over what the jury will be instructed on. So we'll be able to talk more about how the law may be more favorable to one side or the other. Don't go anywhere. More Court TV Live will get you back into the courtroom right after this. Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host. Thank you for being with us on this Thursday. All the evidence is in. Johnny Depp and Amber Heard are off, and the attorneys are heading back into the courtroom before the judge. As soon as they do, and we're going to get a peek at the instructions the jury's going to get on this case, meaning the law that they're going to have to marry to the facts as they've heard them in this case when they go to deliberate tomorrow. Let me bring in my guest, Josh Schiffer. Josh, while we were waiting, we thought they were going to come back, and then we hit the commercial break. But it gives you and me some time here to talk about something you and I were chatting about, was objections. And I know you enjoy going on the Twitter, as do I, and answering questions, and all of you at home give us such wonderful questions. If you have any pertaining to objections, maybe things you haven't understood throughout the trial, Josh and I are here for it. We're here for them all. Send them to us. We're going to be watching that charging conference in a couple of minutes. You had a theory, Josh, about why the Heard team was not making all the objections they could have made with Amber Heard and the cross from Camille Vasquez.
Absolutely. So we all watch this and we see, and lawyers are always analyzing, how's a jury gonna listen? How are they gonna hear? What are they seeing? And we reverse roles with them. And we all watched lawyers like Camille Vasquez just do an outstanding job with a particular type of inquiry. And they realized the strengths that she's going to have, but every strength has a weakness. Everything has an opposite that you can take advantage of. And I think that for the purposes of the entire case, and the theme that Mr. Rottenborn and Elaine are working on, is this abuse with case within a case. By not objecting, they preserve some of that.
Okay, I see what you're saying. So essentially, to kind of put it in, you know, really simply, like they let her get a little beat up there.
Exactly.
Just so she looks like she's being victimized again. Is that what you're kind of...
Exactly. Twisting in the wind, no one can look away, and that's what the jury's taking away. Amber's getting abused in front of them.
Could be what they were doing. All right, it's a good theory, Josh Schiffer. We'll be right back after this.